Okay, well, why don't we get started? We may have some people joining us still throughout the introductions. We appreciate everybody making time to join us for today's Miller-Johnson COVID-19 Response Team Monday Morning Roundup update for May 24th. We've got a few interesting topics to cover as people are potentially getting back into the office today who may not have been there in a while. And just to preview something we'll revisit at the end of the webinar, we'll be having a webinar devoted to some of those new rules that we're anticipating coming out from the state. We have that scheduled for tomorrow morning. So we'll revisit that at the end of this webinar. But we can continue on here with my colleagues, Tripp, VanderWal, and Kevin Sutton. First, Tripp will cover some additional IRS guidance related to COBRA subsidies under the ARPA, the American Rescue Plan Act. And then Tripp will hand it off to Kevin to cover some updates in the education and schools area. And then I will finish things off with a brief discussion revisiting some of the SBA Paycheck Protection Program appeals process procedures as we're moving into a time when that may become more relevant. But I'll turn it back over to Tripp now, who can start us off.
Thanks, Eric, and good morning, everyone. As Eric mentioned, my name is Tripp VanderWal. I'm going to be taking through some IRS guidance. Typo on that slide, it should say IRS guidance, not IRA guidance, with respect to the COBRA subsidies. My presentation this morning, this guidance just came out last week. More of a preview. We are working on a more in-depth webinar that will be coming here in the future, and we will announce that once we shore up exactly when that is going to be. Next slide, please. Just before we kind of jump into what the IRS guidance contained, I thought maybe it would be helpful to give a quick overview of the COBRA subsidies under ARPA, the American Rescue Plan Act. So under ARPA, COBRA qualified beneficiaries who become eligible for two reasons, either A, a reduction in hours, or B, or an involuntary termination of employment, which we call assistance eligible individuals, are going to be eligible for a COBRA subsidy if they elect COBRA. And let me point out here is that the involuntary only applies to the termination of employment. A reduction in hours can be either involuntary or voluntary, and folks will be eligible for this COBRA subsidy. Under ARPA, the subsidy is equal to the entire COBRA premium, so essentially these folks are going to be getting free COBRA. The subsidy is going to be available from April 1, 2021 through September 30, 2021. But it could be terminated early, and really that's going to come up in the way that it can be terminated early could come up in specifically two instances. One, you exhaust your maximum COBRA period, and now typically that's going to be 18 months because the COBRA period, either due to a reduction in hours or involuntary termination of employment, is 18 months. As we'll talk about here in a slide or two, the IRS guidance did indicate that this COBRA subsidy may be available during a 11-month disability extension or a second qualifying event, as long as the period overlaps with the 6-month period. I'm sorry, as long as the COBRA period overlaps with the 6-month period from April 1 to September 30. Without getting into the real nitty-gritty, it's typically going to be the employer that's required to pay the COBRA premium on behalf of these COBRA qualified beneficiaries who are assistance eligible individuals. But the good news is you're going to be eligible for a tax credit against the employer's Medicare tax to offset the cost. And to the extent that, for cash flow purposes or for other reasons, you can actually withhold that into what you anticipate that cost to be against your federal income tax, Medicare tax, and Social Security tax deposits, both the employer and employee share. Again, that's probably stuff we'll be covering more in depth on a subsequent webinar. Next slide, please. So again, the IRS issued guidance last week, Tuesday afternoon, May 18, and it was a fairly substantial document. It's 41 pages. consisted of 86 questions and answers. But the IRS officials have informally stated that, hey, we're still collecting questions from the public, and we may be issuing more. Now, the nice thing about the question and answer format is that it is much more readable than I would say typical IRS guidance is. So, if you're interested in diving into this a little bit more, it is pretty user-friendly to the extent that it can be user-friendly. You can always Google IRS Notice 2021-31, which is the relevant guidance, and take a look at it for yourself. I highly recommend, if you're having to deal with these COBRA subsidies under ARPA or have some questions about that, to look at it. It's, the guidance is even divided up into kind of different subjects, so you can narrow down based on what maybe your question is. Next slide, please. I would say probably the biggest thing that popped out at me is that the guidance said that, employers are not required to affirmatively apply the COBRA subsidy, but rather they are permitted but not required to wait until a qualified beneficiary makes a written request to be treated as one of these assistance eligible individuals. And that's probably not a huge revelation, at least with respect to people that have COBRA qualifying events between April 1, 2021 and September 30, 2021. But you remember that certain COBRA qualified beneficiaries got an extended election opportunity. And specifically, those were those folks that may have been eligible for COBRA but not enrolled due to a reduction in hours or an involuntary termination of employment before April 1, or maybe previously enrolled in COBRA but dropped it before April 1. They basically got, you were required to send them another notice, and they got basically a second bite at the apple to make that election. When you read the statute, I think it was reasonable to interpret that, if you were an employer and you thought these were folks, that either you knew were a reduction in hours or you at least were, or their termination employment, it was not contentious of whether it was involuntary or not. The thought was, maybe I have to turn on the subsidy automatically for these folks. The IRS has said, no, you can, once you send them the notice, you can sit back and wait until they turn in their COBRA election along with one of these request forms. In fact, again, the IRS guidance said you don't have to do that, but actually recommended it because they say, they said, hey, when it comes time to, if you're ever audited for taking the Medicare tax credit, these request forms are going to help substantiate the amount of your credit. And so it's going to be helpful to have those in your possession. And if you don't, you're going to have to rely on some other substantiation to prove that Medicare tax credit again if you were to be audited in the future. Again, I touched on this briefly on the last slide, which was a little bit different than I think how the COBRA subsidies existed the last time they were allowed, which was back in 2009 after the Great Recession, excuse me. And the guidance clarifies that the subsidy is available past 18 months under either an 11-month Social Security disability extension or potentially a second qualifying event. Again, as long as the COBRA period overlaps with this subsidy period of April 1, 2021 through September 30 of 2021. And again, that's a little bit of a pivot from, I think, how the IRS guidance worked the last time it was around, but a notable item nonetheless. Next slide, please. All right, the guidance spends several questions talking about on what an involuntary termination of employment does and does not include. Some of the issues I wanted to highlight is that it does not include a termination due to a general concern about workplace safety. Now, of course, employees can make an argument that either actions or inactions by an employer that materially change the employment relationship in a negative fashion, maybe giving rise to the idea of a constructive discharge. That may, in those situations, it may be an involuntary termination of employment. But again, just a termination due to general, I have this general fear that I may contract COVID of going back to work, so I'm going to leave my employer or leave my employment. That is not an involuntary termination of employment. These next two items I think are fairly related, and I was really interested to see how these are going to come out because I had no idea. But employee-initiated terminations because a child is unable to attend school or daycare because it's closed to COVID, or your inability to find daycare those are generally not going to be an involuntary termination of employment. And again, if you terminate employment in those situations and they're not involuntary, these COBRA qualified beneficiaries are not assistance eligible individuals and therefore are not eligible for the subsidy. Lastly, personal circumstances of employees such as a health condition of the employee or family member, those departures again are not going to be considered, at least generally, involuntary terminations of employment. There are some important exceptions which we'll cover probably later, or you're more than welcome to take a look at the IRS guidance. Next slide, please. So assistance eligible individuals who, again, these are the folks that get a second bite at the apple or separate opportunity to elect coverage. Remember, those are people that were either not enrolled in COBRA as of April 1, 2021, or may have been enrolled but dropped coverage. It clarified that these folks can elect coverage as of April 1, 2021, the first day of the subsidy period. They can also elect it prospectively. And I think this is important, as the guidance points out. If I'm currently enrolled in a health insurance through one of the ACA health insurance exchanges or marketplaces, and I'm getting a tax credit, my enrollment in COBRA is going to make me ineligible for that tax credit. And so therefore, if I have COBRA and a marketplace coverage of the tax credit at the same point, and I'm getting the tax credit maybe in an advanced fashion, I may have to pay that back. So what this allows people to do is to go out and drop their individual market coverage and enroll in subsidized COBRA coverage on a prospective basis. And then finally, remember that we have these EPSA disaster relief notices hanging out there that basically said various employee benefit deadline extensions, including the ability to elect and pay for COBRA, was extended for the shorter of 1 year from basically the original deadline or the end of the COVID outbreak period. The outbreak period ends 60 days after the presidential national emergency for COVID ends, which hasn't ended yet. So we're still going. So possibly, these folks can elect coverage back to the date that coverage was originally lost, even if we're hanging 7 or 8 months after that date. But of course, if an individual elects COBRA before April 1, 2021, they're going to have to pay COBRA premiums for that COBRA coverage because the subsidy only covers the period of April 1 through September 30. So I guess this all means is that AEIs in these situations, these folks that have extended election opportunities, are probably going to have to specify the date that they want COBRA to begin. Next slide, please. All right, and then finally, rounding this out, the Medicare tax credits. Remember, you can offset the cost of your providing free COBRA to qualified these AEIs through a tax credit against the employer's Medicare tax. I think this is no surprise, but just wanted to confirm this. If you as an employer voluntarily agree to pay for someone's COBRA premium, such as through a severance agreement, you can't shift the liability to the government through claiming a tax credit. And so what I think you also, with this guidance, did go a little bit further and said, really, if you are an employer that's got kind of a program and arrangement out there where you are subsidizing COBRA for similarly situated employees who are not assistance eligible individuals, so maybe folks that had just a voluntary termination of employment, or any other ways, if you are providing them with some type of COBRA subsidy, maybe you're extending coverage at the same price you would to active employees, and you just try to say, well, no, I'm not going to do that for assistance eligible individuals because they get free COBRA and I get a tax credit. That may not work. If you are audited by the IRS, they may try to disallow that, saying, this program is a voluntary subsidy, and therefore you can't claim the credit on behalf of the AEIs, just like because you're also providing it to other COBRA qualified beneficiaries who are not AEIs. Next slide. With that, I will kick it over to my partner, Kevin. Kevin, take it away.
Well, good morning, everybody, and good morning, Tripp. Thank you very much. I got to say, I'm thankful for all of my Miller Johnson colleagues, but when I hear Tripp go through that information, it makes me a little dizzy, and I am so thankful that we have experts like him and like Erik to make sense of some of this stuff. So thank you, Tripp, for getting us started this morning and walking us through that. Good morning, everybody. I'm Kevin Sutton from the Education Practice Group. I'm located here in our Detroit office. Good to join you this morning, and going to talk about a couple of important developments that we had in education world last week. Some big notable developments. In fact, the Michigan, the My Blueprint for Comprehensive Student Recovery that came out last week, and then Senate Bill 118, which was enrolled and signed into law last week to provide flexibility to school districts during the pandemic as it relates to certification and staffing. So two big, very important developments that we'll walk through here for a few minutes. First, we're going to talk about the My Blueprint for Comprehensive Student Recovery. And of course, My being the MI, we've gotten very good at branding things that way. And I think before we get into the nuts and bolts of it, if we take sort of a big picture view of what we're dealing with and why we got the My Blueprint. So much of this school year, understandably and realistically, has been about survival. Not just physical survival, but getting through the school year in unprecedented conditions, right? Finding a way to have student engagement and student learning, dealing with sometimes the equity issues that exist from an access standpoint, getting online, having enough Chromebooks. Some student learners are learning great online, others are not. And how do we manage that? And of course, issues of staff fatigue, which are very, very real and understandable as we sort of get to the end here. And we are just a few weeks away in the K-12 world for finishing out the school year. We're starting to look forward. And that really is what the My Blueprint for Student Recovery is all about, is, okay, we've had this terrible, difficult 15, 16 months. What do we do in the next chapter as educators, both K-12 and post-secondary, to try to help students catch up? So the why is, we obviously understand it's been a pandemic and it's been a challenge, but obviously issues of student mental and physical health. We know that there have been, during this pandemic, increased reports of domestic violence, child abuse and child neglect, substance abuse, and other difficult and terrible things that have gone on that have impacted, not to mention just kids not being able to get up, get on the bus, and go to school every single day. From a student achievement standpoint, the group that put together this My Blueprint for Student Recovery, which was a comprehensive group with stakeholders from all different facets of education, estimating that when students return in the fall at the K-12 level, there'll be a 63 to 68% of learning in reading gains compared to a normal year. So only got about 63 to 68% of what they would have normally gotten in a year. And on math, the numbers are even more daunting, only a 37 to 50% gain in math learning compared to a normal year. So from a student achievement standpoint, obviously we have some ground to make up. In the post-secondary world on higher education, fall 2020 college enrollment dropped by 4.4%. 4.4% doesn't sound that terrible, but that's 5 times greater than the drop we saw in the fall of 2019. One thing that I give this group a lot of credit for, and we'll talk about some of the specifics that they mentioned for post-secondary in a moment, a lot of times these groups are very heavily focused on K-12. And this My Blueprint is heavily focused on K-12, but they didn't ignore post-secondary. Sometimes we see that happen, but there's something really for everybody in this recovery plan. And I think that was a very good step by the group to do so. So the plan itself is multi-year is the phrase that is used. And really what they're viewing is the next 6 to 18 months really being integral in school districts taking the steps that are talked about in this plan, at least considering the things that are talked about in this plan to try to close this gap, this achievement gap that we've had. Nothing in the blueprint is mandatory. It's simply a tool for schools to use to try to have some recovery, but it's all there. It is very, very focused in I will say in educator speak in a favorable way about being evidence-driven, evidence-based and equity-driven. There's much attention given to that throughout the course of the plan. And so that's the framework for why we have what we have. Next slide, please. So we're really broken out into 2 sections. And the first section is, I sort of think about who is the audience for these various sections. And so section 1 is the biggest section. And your audience there are superintendents, educators, educational organizations, school board members, school leaders, all of the major stakeholders that we have in the world of education. And the topics, as you might expect, wellness, academics, school climate, family and community engagement, and then, as I mentioned, post-secondary as well. I think the first four speak for themselves in a K-12 world. Relative to post-secondary, they did call out some very specific things that I wanted to mention because I thought that it was, again, very insightful that they did it. They talked about having access to high quality pathways. What are the pathways that students can explore at a post-secondary level and having access to those things? Very practical challenge for a lot of students, progressing towards their degree on time and how to address that. And also they identified incomplete or inaccessible information regarding the various pathways that are out there and or careers that students can explore at a post-secondary level. What they've done for each of these, in each of these categories, is they've identified root problems. They've showed the root cause, what the goal would be, supporting evidence, high leverage actions that can be taken to remedy it, and then in many instances tried to give examples of high leverage actions that people in Michigan have taken to try to address the various concerns that arise under these different categories of student achievement and engagement. Just as an example, and I could have picked any, one of the challenges was a decrease in student physical activity, right? Obviously, we have students who, if they're home, they're online, they're not going out for recess every day. There are some deeper concerns outlined in the plan, but this is just one. And they cited Battle Creek Public Schools has something called Operation Fit, which includes morning movement and lunchtime programs led by community volunteers to help students increase their physical activity and create healthy habits. So just one example that they provided of a high leverage action that we can take to address one of the root problems that exists as a result of the pandemic. Again, that was a physical activity one. There's obviously ones that are focused very specifically on academic achievement, so on and so forth. So that is the bulk of this 40-page My Blueprint plan, is section 1, which is identifying these problems, again, providing evidence and talking about the high leverage actions that educational organizations can take to try to address these issues. Section 2, which is the smaller portion of the My Blueprint plan, are policy recommendations to promote this comprehensive student recovery. And if we're thinking about our audience again, our audience for section 2 really is our state policymakers, those that are in the business of creating structures legislatively and otherwise for us to do what we need to do. And I will say my read on this is it's a bit of a swing for the fences, but why not? Obviously, we have a unique moment in time here for a lot of reasons, and I commend the group for the hard work that they did in making some very concrete recommendations for how we can have long-term comprehensive student recovery. I don't think it's a mistake that the first 2 bullet points you see there have the word funding in them, talking about adequate and equitable funding and talking about consistent funding. Anybody who's been around K-12 or higher ed knows that funding is a major issue. And that's not the teachers whining about more money. That's just trying to make sure we have some consistency in our budgets and how we're handling things, talking about attracting top talent. Universal pre-K is a legislative prerogative and something that we should look at doing, and then innovation in teaching and learning from a policy-making standpoint. All things that if we're able to do that, it will facilitate our ability to achieve the objectives outlined in section 1 in trying to have this concrete growth, comprehensive student recovery. So that's the 2 sections that we see in the My Blueprint plan. Next slide, please. So how do we do this, right? It sounds great. We know that we've got a problem. We've identified root causes, and it could seem daunting. So how do we get there to fix all of these things? Because obviously, we know that the next school year and beyond is going to be pivotal, and there's a lot of ground that we need to make up. And so what they've talked about is sort of recovery steps that every school district or educational organization can take to try to cover up with these things, try to kind of catch up and address these root causes. And we need to be, intentional about these things. And I thought this was really nice, the way they laid out for organizations who might feel overwhelmed by the prospect of doing all these things, some steps that you can take. So obviously establishing a recovery committee, ask that committee to draft and implement our recovery plan that is unique to our district and inclusive of all of the stakeholders in our district. Reviewing the blueprint for community needs, which means looking at it through the community lens and what does the community really need. I think very, very importantly of this entire list is number 3, prioritizing the challenges. The challenges are going to be many. There is no doubt about that. And it's not practical to take on every challenge that we have. But as an organization, let's focus on the most critical challenges that we have in our district and how can we address those. Certainly considering how student support may be implemented is going to be really important. How are we going to allocate staff? If we need new staff, how are they going to be allocated? Are we going to have responsibilities that need to be redefined? Or are we going to expand responsibilities for existing staff to try to address these unique challenges that have emerged from this pandemic period? As we would in so many other things, engaging the community is going to be important, acting in a transparent and intentional way. We're going to need to ultimately finalize a plan so we know where we're going. We're going to need to build a budget. Thankfully, there's some federal money flowing in to make sure we can do that, to allow, again, over time, multi-year, 6 to 18 months, maybe even 24, how we accomplish these things. Make sure our community knows what's going on that front by sharing it, sharing the plan with them, and then obviously hiring and implementing. And I think from an implementation standpoint, most educational organizations are very, very good at measuring short-term and long-term effectiveness. And I think those are things that we're going to want to make sure that we're doing here as we try to address the myriad issues that we face following this pandemic. So a brief editorial comment, really kudos to the group. I think that they did a very, very nice job. The document itself is available online on michigan.gov/student recovery. It's a very pretty document, lots of graphics, but about 40 pages and a lot of really, really good stuff in there, a lot of good research, a lot of good links for people to follow. And again, some very concrete steps that organizations can take to try to address these issues. And so quick overview there of the My Blueprint for Student Recovery. With that, we'll go to the next slide. And I think there's even a title slide maybe there in the middle. Yep, we're going to talk just one more slide after this about this Senate Bill 118, which came out last week and was passed, adopted, and signed into law on May 19th. And this is probably seems a little bit highly nuanced, but really, really critical and very, very helpful. Those of you in education world know that we have certain requirements from a certification standpoint. And pardon me, if the state finds out that you have somebody who isn't properly certified in a position, that can lead to significant financial penalties. And that's obviously something that we don't want. We need to make sure that we're flowing every dollar we have into student achievement and student recovery under the My Blueprint. And so this is a technical thing, but really, really important. It's an amendment to the School Aid Act that reduces penalties on school districts for employing staff in violation of certification and other credential requirements. We've heard the anecdotes in the news, we've seen the paper, teacher shortage, not only teacher shortage because there's a lot of burnout, not only teacher shortage because there's a lot of people retiring, but we are just facing a teacher shortage generally. And so we're scrambling to find people in many instances who can fill positions, who can teach our students. We've been given, I don't want to say a free pass, but a free pass for the last calendar year, July 1 through June 30th. Going to have that reduction in penalties, and then going forward on July 1, when the new school year officially starts, 50% reduction for non-compliance after a 10-day notice period. Then you go to 100% deduction for non-compliance. And so what we see here is really a bipartisan effort to give school districts a little bit more latitude, a little bit flexibility, and recognizing the very real problem that we're having of staffing. The hope is that this will stabilize and that we'll be able to have the right type of certified personnel in place. But in those hopefully rare instances where we cannot, the state is not going to come down on us like a ton of bricks and send us a big check, a big bill rather, for us to write a check. And that's good news. That's good news. And I think this is, again, a good example of our legislature coming together in a bipartisan way to try to address a very practical concern that school districts had as they've tried to, I'll say scramble in a favorable way, scramble to try to make it through this school year and staff their classrooms in a meaningful and appropriate way. And so maybe starting off on Monday with two kudos, one to our work group, one to the legislature is a great way to start and a great note on which for me to close and turn it over to my partner, Erik. Thanks, everybody. Erik, it's all yours.
Thank you very much, Kevin, and also Tripp. And just to echo Kevin's comments, it's so great to have experts like Tripp and Kevin to help navigate some of these fast-breaking developments and technical areas of the law that are being amended and evolving in real time. So thank you both for joining and sharing your expertise with us and with the community and our webinar participants generally. I'll be talking about something that we've covered in the past, which is the appeals process for Paycheck Protection Program loan forgiveness determinations. We can move to the next slide. The SBA originally published this appeals process, oh gosh, I guess it was 8 or 9 months ago. I believe it was August of 2020. And if we put ourselves back at that moment in time, that was when the first round of the PPP was coming to a close before any of the, well, it had been extended once, but it was maybe a second time, but it was before the second draw PPP loans and the current extension through the end of May. So SBA was promulgating rules with an eye toward processing forgiveness applications. And they've done some of that, especially with loans below $2 million, which are not necessarily subject to the automatic review procedure, but probably not as much loan forgiveness application review as borrowers, especially the larger borrowers, would have hoped, in part perhaps because of the extension of the PPP program into this year and the ability to process more loans, in part because of the grant programs that were put into place through the Restaurant Revitalization Fund and the Shuttered Venue Operator Grant Program. In any case, to the frustration of many large borrowers in particular, the forgiveness review process has dragged on for quite a while. And so the first bullet point here, I had hoped that the numbers would have been updated over the weekend, which is why a couple of them are in brackets. But unfortunately, this is the latest info or latest date of info that we have for loan forgiveness. I just checked again, and still May 10th data. There were over 180,000 PPP loan forgiveness applications under review with a total principal amount of $84.3 billion. And in addition to that, there were close to 180 billion, about 176.8 billion in loan forgiveness applications from 2020. So kind of the first draw PPP loans that SBA had not even received from borrowers yet. So that's sort of the impetus of revisiting this topic, is that the PPP loan program is really out of appropriations at this point, except for certain small lenders. And the Restaurant Revitalization Program will stop accepting applications today at 8 o'clock, I believe, Eastern time, for those who may be trying to get an application in under the wire there. And then the SVOG, or the Shuttered Venue Program, that's been open for a while, seems to be running. I think SBA said they're planning on starting to fund those grants this week, after saying that they had hoped to do it last week. And so the big picture is that SBA seems to be in a position where staff and resources can be deployed more fully to the forgiveness review process. And so we thought that it would make sense to kind of come back here, look at the interim final rule that was put out in August of 2020, and talk about some key takeaways from that IFR. It really has not changed in any meaningful way. There's not been any FAQs or subsequent superseding rules. So, you know, if you're already well versed in the IFR that was put out in August 2020, that's largely what we're going to cover here. But you may be like I was when I was revisiting it, a little bit rusty on some of the specifics, and so I think it's good to revisit and be prepared. So big picture, the IFR makes it very costly and time consuming to pursue an appeal. That's kind of the major takeaway. and there are details that we'll go through now specific to that. So we can go to the next slide. The first is, you may think, well, I'm an owner or co-owner of a PPP borrower. You know, can I appeal a forgiveness determination sort of in my individual capacity? The answer is no, unless you are a self-employed individual or you're the only owner, for example. It has to be the borrower itself that appeals the forgiveness determination that you get from SBA. So if you're an individual owner and you're just one of 3 votes, say, and the other 2 votes don't want to appeal, you really don't have the ability to file an appeal unless you control the company itself that was the borrower. So that's an important thing for people to realize if they're one of a number of owners or partners in a partnership. We can go to the next slide. We'll go through this pretty quickly. There's a lot of information here, but I want to be mindful of people's time. So what can be appealed? It's really only final SBA determinations. So some people are probably in this phase of the process where they've submitted their forgiveness application to their bank. Their bank has said, yep, this looks good, or the bank requested a couple additional documents, and then they said, okay, we're ready to make our recommendation as lender to the SBA that this loan be fully forgiven. And then if your loan was above $2 million, you may have received a Form 3509 need certification questionnaire that had or has a number of questions about quarterly revenues and your cash balance before you got the PPP loan, things like that. And if you're at that stage, you're still not in a position where you can appeal anything. You're still waiting on a final SBA decision. And in fact, even if the SBA is inclined not to forgive your loan, if you've only responded to the Form 3509, you're probably still a step or 2 away, because the SBA has said that they will likely follow up with borrowers that submit responses to that questionnaire that they believe warrant further review. So before you get a final determination from SBA, there will probably still be a little more back and forth after that Form 3509 process before you get a final decision from SBA. And so you may get a determination that your loan is fully forgiven, and that would be ideal. Obviously, there's nothing you want to appeal there, I presume. But you may get some people may get a determination that they weren't eligible for a PPP loan in the first place because maybe their need certification was not made in good faith, or you weren't eligible for the full amount of the loan, like your calculation of the loan amount that you received was incorrect at the very beginning of the process. And so maybe you don't get the full amount forgiven, or you didn't use the funds for appropriate uses. In any event, those are all things that once you get a final determination of that from SBA, you can appeal to SBA and request a review of that determination. If you get a partial forgiveness determination, but not full forgiveness, that is something you could also appeal. So you have to wait until you get that final SBA determination. You're not going to appeal a preliminary determination by your bank or any request for information from SBA in all likelihood. Although if you get something that you consider totally inappropriate in terms of a request, you should probably reach out to counsel to make sure that, you're responding appropriately or that the question is appropriate before you respond. Next slide, please. Okay, so you'll make your appeal to what's called the OHA, or the Office of Hearings and Appeals at the Small Business Administration. So you're not appealing to, say, a federal district court, and at this point you're appealing really to an extension of the SBA itself. This is the same appendage, if you will, of the SBA that has historically heard appeals about size eligibility for different SBA programs before the PPP. So SBA administers other normal pre-pandemic programs like just Section 7A loans and size determinations for certain government contracting opportunities, for example, that require, in some cases, a borderline decision about whether the business is really a small business. So the OHA predated this whole appeal process, but they're, like the rest of the SBA, they're probably going to see a ramp up in the amount of appeals and the volume of the work they're handling as a result of the PPP. So that's where you're going to make your first appeal, and you need to include really a variety of information, because you must include in your appeal a full and specific statement as to why you believe, or your advisors believe, that the determination by SBA was erroneous. And you need to include any factual information or legal arguments to support that. You only have 20 pages to make your case in that first instance, and no new materials can be added to the record at that point. So you're really relying on information you previously submitted to SBA, or information that you provided as part of, responses to the Form 3509, for example, or subsequent questions from SBA. Next slide, please. Okay, you got to move pretty quickly once you get that final determination from SBA. So you really only have 30 calendar days from whichever occurs first, notification by the lender to you of the final SBA determination, or your receipt from SBA directly of the loan forgiveness determination. So it's not a huge amount of time to, if you haven't already put together a good file of support for your loan forgiveness request and your need certification, it's not a lot of time to pull together all that factual and legal information you might need to make a good case. So this goes to that point of, an ounce of prevention is worth a pound of cure. So you want to make sure you've been keeping good records, especially if you're one of those larger borrowers, so that if you do need to, pursue an appeal, you're ready to get in touch with counsel and any other advisors quickly to do so. And by the way, people are probably aware that the SBA has taken well beyond their 90-day time frame to make a determination about forgiveness. And I don't think we should count on SBA granting the luxury of any additional time to borrowers, just because SBA has taken longer than it gave itself to make their decisions in the first instance. Next slide, please. So the standard of review and the burden of proof is pretty well stacked in favor of the SBA. So it has to be a clear error of fact or law, and the borrower, so that you as the appellant, must bear the burden of proof by a preponderance of the evidence. So again, it's a bit of an uphill battle. You got to wait till after you get the SBA determination, and then overcome, by virtue of this burden of proof, you got to overcome that pretty clearly, and show the clear error of fact or law that SBA made in whatever denial of forgiveness they may have sent you. Next slide, please. Okay, and then so you've submitted your appeal. If it's been made timely within that 30-day period, and you've included the right information, then OHA will assign an administrative law judge or an administrative judge to review the appeal. So again, you're not at a federal district court judge or any kind of federal magistrate yet. You're still sort of within the SBA framework. Conceivably, you could, together with SBA, agree to some kind of alternative dispute resolution at any point in the process, but there's nothing requiring SBA or the borrowers to pursue that before jumping right to the OHA process. Next slide, please. Again, there's generally not going to be additional discovery at this point in the process. Really, the OHA and the administrative judge are, for the most part, barring some extraordinary circumstances, going to be relying on information that's already in the file, so to speak, for that PPP borrower. The SBA will have to, give the administrative judge everything that it has in its records. If the borrower thinks that there's something missing from that, they can supplement it with information that they believe they provided earlier in the process. But typically, the administrative judge is not going to be able to request or supplement additional material at this stage, and really, you're limited to just objecting to the absence of things that SBA should have provided to the administrative judge because they were already in the record or were already furnished to the lender or SBA. So you shouldn't count on, again, being able to supplement the record later by, bringing in a new witness or submitting a new affidavit or something like that, which is why it's important to be thoughtful about those Form 3509 responses and what is and isn't in the record if you're doing that with an eye toward an appeal. Next slide, please. Generally, there will not be any kind of oral hearing or argument, only if there's what they say, a genuine dispute of material fact that cannot be resolved except by taking testimony or confronting witnesses. So that would be pretty rare, especially given that there's likely to be a large, I would imagine, unless SBA provides some kind of blanket forgiveness for virtually all the large borrowers so that there's very few appeals. I think it'll be unlikely that there's going to be a lot of oral or other hearings in these PPP appeals, just because it will be so time consuming to administer all that. And there's really no so once the borrower has submitted its application or its appeal document, the SBA will have a chance to respond. And the borrower does not have an opportunity generally to respond or reply to the SBA's response to its appeal petition. So again, it's just going to be a fairly discrete universe of material that this administrative judge will have for making the appeal determination. Next slide, please. Okay, so any other ways you can appeal? This process seems pretty favorable to the SBA so far, and let's assume you don't get the determination you want on that first appeal. You can request reconsideration by the OHA, or they might initiate their own reconsideration review. You can appeal to the SBA administrator. So the head of the SBA, basically, in their office to review. And then if you've gone to that step and you're still not in the position you want, or you're not willing, you're not of a mind to accept the results, you want to continue pursuing appeals, then at that point you can appeal to a federal district court. And it's important, you just have to go through that SBA appeals process first, unless you're going to challenge the SBA's rulemaking itself on the appeals process to say that somehow it violated the Administrative Procedures Act or something like that. You're going to have to go through the SBA itself, and then you can appeal to a federal court to preserve your ability to continue to obtain forgiveness. Otherwise, if you don't appeal to federal court after you go through the SBA process, you're basically done at that point, and your right to further appeal is deemed waived, essentially. Next slide, please. And our attorney's fees recoverable? No, there's no prevailing party recovery for attorney's fees throughout this process. So even if you prevail, but especially if you don't, I mean, in either case, you're not going to be recovering your attorney's fees or other expert fees as part of this process. So Again, it just makes it very time consuming and expensive to potentially pursue this appeals process, especially if you need to go all the way to a federal district court. So again, it's just, if we go to the next slide to kind of take stock of this whole process, it's really important to be thoughtful about your responses to those Form 3509 questionnaires. And I know I've talked to a number of clients about those, and sometimes you want to be, you want to respond with some background explanations, but I'd say more often than not, you just want to answer the questions that are provided, unless there's something you really want to be certain gets into that potential record for appeal. If you're really uneasy about your forgiveness request for some other reason, most of the time you're still going to want to just answer the questions and not delve into a lot of additional supplemental information, and just give the SBA the facts that they request in that form, because you'll still have an opportunity to, per the SBA's FAQs, there will be another opportunity to provide additional information to SBA before they make their final determination. So there will be, if you don't get forgiveness after responding to the Form 3509, there should be another step before you get that final SBA decision where you can supplement the record with additional context and explanation. So I don't want people to walk away from this thinking that, they should load up their Form 3509 responses with just everything and anything, because that could be problematic too. You don't want to give the SBA, a bunch of new avenues to request additional information about. So I still think more often than not, you want to be just to the point in those responses, but occasionally if you're sort of on the borderline, there might be an opportunity there to get some materials or information into the record to, with an eye toward a possible appeal. And then, again, I think just preparation is key here. Make sure that you're ready to hit the ground running if you do get that final determination that a meaningful part of your loan is not forgivable or you weren't eligible in the first place. You don't want to be starting from scratch with a 30-day ticking clock. And I know a lot of our clients won't be in that position, because in talking with you all, I know that, you've been keeping great records and about both your eligibility and your use of the fund. So just make sure you keep those things organized, and, you have to hold on to that information for at least 6 years for most borrowers after the loan forgiveness process is complete. So hold on to those things, make sure they're accessible, keep good records internally, and reach out to counsel as appropriate and necessary. We'll always be here to help you respond if you get any inquiries. So with that, I am done with my portion. I do want to move on one more slide here to talk about our event tomorrow. So we can go to the next slide, please. We have a webinar scheduled for tomorrow morning with our employment law colleagues to talk about the expected new MDHHS and MIOSHA guidance that I think we're anticipating should be coming out today, how that fits in with some of the CDC guidance. I know this is a big topic for many of our clients and webinar participants. So if you haven't registered for that already, definitely recommend it. Just like Tripp and Kevin in their areas, the employment law team is all over these developments, and they really understand the ins and outs of all the rule makings and how any changes impact your day-to-day and your employees and how you operate your business as folks are starting to come back to the office more. So I don't see any Q&A lined up here. And so with that, I'll just say thank you again for attending the Monday morning roundup here for May 24th. As always, we really appreciate folks taking the time out of their to start their week with us. We'll not have a Monday morning webinar next Monday. It's Memorial Day. but we may have some other programming during the week. So we'll communicate that out to folks, and we hope you have a great week. For the educators on the line who may have been attending for Kevin's portion, good luck with the end of the school year, and thank you for everything you've been doing for the students here in Michigan. We really appreciate that. I think all of us on the line have children, the panelists anyway, and we appreciate all the hard work that administrators and everybody else has been doing on that front. So as Kevin said, you finished strong, and we'll all try to finish strong here through COVID and get through this. But I hope you have a good Memorial Day weekend in the meantime, and we'll talk soon. Thank you.